Good morning, Mr. Dean. And we're scheduled today for a case conference. Rodriguez, why don't you get me somewhat up to speed, although I will say I've reviewed the file and I feel like I'm quite familiar with it.
All right, thank you, Your Honor. Just so the court is clear, today was unilaterally scheduled by Mr. Dean. He scheduled simultaneously 3 case management conferences in December, and we notified him. I had another hearing, I had meetings. I obviously didn't want this going forward without me, so I rescheduled everything to be here. Mr. Dean, I said I'm available on January 23rd, which was one of the 3 dates. I believe Your Honor is the 5th judge on this file. We've had multiple hearings on Mr. Dean's outstanding motions. We've never gotten a hearing on our motion for psychological evaluation. We obtained a special set date in May, I believe it's May 3rd, from your judicial assistant. We asked Mr. Dean if he was available. He would not respond. We are requesting our motion for psychological evaluation and then a final hearing date. This is a very old case. Mr. Dean has, 2 judges have sua sponte recused themselves in this case. We need to get this couple divorced, but we do need a psychological evaluation.
All right. Mr. Dean, I know you've contacted my chambers quite a bit. Okay, let me be abundantly clear. I will not tolerate you constantly contacting my judicial assistant via email and phone calls, numerous phone calls, numerous emails in one day. We have over 1,000 files in this division, in Broward, and your behavior is not going to continue in that fashion. Furthermore, I'm familiar with the posting regarding Judge Masterigo. You are not to post anything about me during the pendency of this case. You're not to reach out to me. Do you understand?
I would like to ask you why this morning
you're not going to ask me questions, Mr.
I haven't even spoken yet, Your Honor.
You need to respond to my question. Do you understand what I explained to you, that you will not post anything about the pendency of this of the litigation in this case, and you will not reach out to me as well? Do you understand?
I understand what you're saying. Correct. I comprehend what you're saying.
So that is a direct order, sir. You reached out directly to Judge Masterigo through social media.
No, I deny that allegation, and if you would like to have a hearing about it, we can do so.
All right. We don't need a hearing about it, but you will not reach out.
Well, what you're doing is you're bringing hearsay into the court this morning, and what I've done is I prepared a statement to read to the court this morning.
You're not reading a statement this morning. We're here for a case management conference.
Mm-hmm.
Ms. Rodriguez, aside from the psychological evaluation, the motions are pending?
Your Honor, there is a motion that we've requested for all hearings to take place via Zoom. There was a lot of sheriffs at the last hearing. It took a lot of court resources. Judge Mastriago had to be escorted to her car. We're requesting that all hearings take place via Zoom. My understanding is most of the time Mr. Dean is in Guatemala, so it should accommodate his issues. He's had several hearings, all of which were heard in person by Judge Coleman, who held him in criminal contempt. Judge and the hearing ceased once that occurred. I have the transcript. His hearings were again heard by Judge Mastriago, all in person, and orders were not entered because Mr. Dean had communications with the court, and then Judge Mastriago sua sponte recused himself. We have never had a hearing on our motion for psychological evaluation, but he's had 2 half days on both of his motions with 2 different judges, Your Honor. We're requesting our motion for psychological evaluation be heard, and then a final hearing can be set on all outstanding issues.
All right. And Mr. Dean, what motions on your end do you believe need to be heard?
There's approximately 20 outstanding motions, and not one thing that we just heard from opposing counsel was true. And that actually brings me to my statement, which I am going to make to this court, because
you're not reading a statement.
So you don't want me. You're only going to let the other side speak. Is that correct?
You're going to tell me which motions on your end you believe.
How can I do that without speaking?
All right. So I guess no motions on Mr. Dean's end need to be heard.
That's not what I said. There was at least a.
All right. We're gonna schedule.
Okay.
Ms. Rodriguez, we will schedule your motion for the psychological evaluation, and then get a trial date. Mr. Dean, what's your position on whether it should be on Zoom or in person?
This case is nowhere close to being ready for a final hearing. I have at least a half dozen motions outstanding. Namely, the court needs to. The court. If I may finish making my record, please.
This is going to run a lot smoother if you listen to my questions and answer my questions rather than just going on saying what you'd like to say. So the motion for psychological evaluation and any other motions, what is your position on whether they ought to be on Zoom or in person?
They ought to be in person.
I have no problem with them being in person. If he's objecting to Zoom, we're going to do it in person. Just so that, again, we're clear, Mr. Dean, I know there was an issue regarding videotaping at a prior hearing.
Mm-hmm.
You're not allowed to videotape these proceedings. You can hire a court reporter if you'd like. That is the way to document what transpired in court. But you are not authorized to audio record these proceedings or video record the proceedings. Do you understand?
This feels like you're ambushing me here this morning. All I hear is, do you understand? Do you understand? Do you understand? And you're asking the other counselor, hey, what would you like to do? We'll do anything you want. And you're admonishing me, and you won't let me speak. And I don't even know who you are. We've never met before. Is there a reason you're speaking to me this way when I've never seen you before?
So do you understand what I asked you, sir?
That's why you keep saying.
So I take that as you understand.
You're indeed the seventh judge on this hearing, not on this case, not the fifth judge. And if you're not willing to accept the fact that 7 judges fragments the understanding of the events and the issues at stake, it's a mistake.
Okay. So how much time do you need for the psychological evaluation, Ms. Rodriguez?
Is there a reason why we're jumping ahead with that motion when there's so many others pending before it, and that actually must, according to law, be heard before that?
Ms. Rodriguez, how much time do you need?
1 hour,
I see.
Your Honor.
So it's my understanding that you have no intentions of providing a fair and impartial case. Is that correct, Your Honor?
Maria, we're gonna propose 3
I
dates.
take that non-answer as affirmation.
Maria, we're gonna pose 3 dates for the 1 hour psychological evaluation, and also set it for a status. And maybe on that day, Mr. Dean will be prepared to tell me which motions he believes need to be heard.
I thought you read the emails, and I articulated very clearly in those emails what you said.
I muted you, sir. You cannot interrupt me when I'm speaking. Maria, you're going to email them with 3 dates. If they can't agree, I will select a date, okay? And we'll have a 1 hour in-person hearing on the psychological evaluation. It'll also be set for a case management on that day, so that we can schedule the remaining hearings in the final hearing. Okay? All right, I have a pretty lengthy docket,
Respect must be mutual. You can't cut me off and then ask me not to cut you off. And I can go ahead and tell you we don't need to bother, because I'm going to be filing another motion to disqualify you, because what you've done this morning is inappropriate.
So this hearing's over. Okay, so you're excused. I'm going to move on to other hearings.
Your Honor, may the 2 hearings that the remaining case managements be canceled?
This hearing is over. Have a good day.
We scheduled a case management on January 23rd and January 30th. We had the one today since I canceled my morning.
Yes.
I don't want my client to incur the cost.
Mr. Dean, you're not going to be allowed to schedule things without my approval. Okay, so I will.
Only the other side is allowed to do that, Your Honor?
No, I will be the one scheduling things in this case. Okay? No, neither side will schedule anything. I will schedule everything on this case. You're both excused. Thank you. Have a nice day.
Thank you, Your Honor.
Take care.
We're all good on our side. We're good for the temporary leave date, 3/28, 8 a.m. to 10 a.m. in the night.
So we can see justice is not going to be served so easily. All I did was appear, and I was being admonished before I even said a single word. I scheduled that case management conference, and I should have been the first one to be able to speak. And she went straight to the opposing counselor to ask basically, how do you want to railroad this guy? As you can see, judge number 7 is she's going to try to force status quo on me and continue the same direction that we've been going in now for 3 years. And that's unfortunate because while she allowed the opposing counselor to make a full statement just now, she wouldn't allow me to say a word. While she was telling me I'm not allowed to cut her off, she cut me off every time I spoke. Respect is mutual, it's not one way. And as we can see, the court feels like she's above the law. I'm not. I refuse to be spoken to in that manner. I refuse to be railroaded. I refuse to let fathers go out like this. And I'm going to stand for all fathers. And I'm going to make my statement here to this camera that I was going to make to the court. So the record is clear. Your Honor, my service to this nation, highlighted by the Presidential Unit Citation, mirrors the highest collective honor, akin to the Medal of Honor for individual bravery. It is a testament to facing adversity with valor and unity, qualities that underpin my pursuit of justice within this courtroom. As we move forward, it is essential to understand that these traits are the bedrock upon which I stand in seeking a fair resolution to these proceedings. The conduct of the opposing party and her counsel stands in stark contrast to the honor of fair play and justice. Their actions have moved beyond the pale of reasonable litigation into the realm of systemic fraud and legal abuse. This behavior, which has significantly hindered my ability to maintain a relationship with my children, cannot be overlooked and requires immediate rectification to restore the integrity of the legal process. With the complexities of this case sprawling beyond the purview of brief judicial interactions, I implore the court to authorize a comprehensive social investigation and engage amicus curiae. These steps are not mere formalities, but are essential for shedding light on the true dynamics at play, which have been obfuscated by the opposing party's misconduct. The rotation of 7 judges through the life cycle of this case has resulted in a fragmented understanding of the events and the issues at stake. Establishing a stable judicial presence is paramount to ensuring that decisions are made with a complete and continuous understanding of the case history, particularly given its direct impact on my children's future. As a father unjustly separated from his children, I stand before the court to appeal for a path forward that honors my right and duty as a parent. For 3 years, I have been estranged from my children due to a series of uncorroborated allegations and a legal system that has yet to rectify these wrongs. The injunction placed against me without proper accusation or hearing has only perpetuated this separation. This case began with a disproven claim of domestic violence. Yet the shadow of that claim continues to unjustly dictate the terms of my relationship with my children. The time has come for the court to take definitive action to redress these injustices. A just path forward begins with lifting the baseless injunction that has marred my reputation and hindered my ability to be a parent. It involves establishing a framework for my children to have the benefit of two parents involved in their lives, as they rightfully deserve. For nearly 2 years, the current injunction has stood as a barrier to this fundamental right, with no substantiated basis. Justice must prevail not only in word, but in action, beginning with the court scrutinizing the events that have led to this prolonged separation. The court must consider the damaging effect this has on the welfare of my children and act swiftly to restore my parental rights, thereby enabling a healing process that allows for the rebuilding of my relationship with my children. This path forward entails setting aside the injunction that has been unjustly imposed upon me, facilitating a fair and immediate reevaluation of custody arrangements, and ensuring that the petitioner adheres to the court's orders without evasion. It is only through such divisive measures that the court can protect the best interests of my children and ensure that justice is not just a concept, but a lived reality for my family. I urge the court to consider the grave impact of these years of separation on both a father longing for his children and the children who have been without him. I stand ready to cooperate with all necessary investigations and proceedings, and I do so with the hope and expectation that this court will act to mend what has been broken starting today. As this case languishes in a state of judicial inertia, I wish to draw the court's attention to the numerous outstanding motions that continue to impede progress toward a resolution. It is a matter of record that the opposing party has filed an abundance of motions frequently labeled as emergency or urgent. However, there is a stark disparity between the purported urgency of these filings and the opposing party's actions, which show a willful negligence in prosecuting their claims. This pattern of behavior exhibits a strategic misuse of emergency motions as a means to manipulate the court's docket, thereby prolonging the proceedings unnecessarily. Such tactics not only burden the court's resources, but also serve to perpetually extend a state of uncertainty and strife within my family's life. It is a calculated effort to exhaust both the judicial system and my own capacity to seek justice. The urgency with which these motions are marked stands in direct contradiction to the opposing party's lack of diligence in pursuing them. This approach not only hinders the timely administration of justice, but also detracts from the genuine emergencies that require the court's immediate and undivided attention. I respectfully urge the court to recognize the dissonance between the opposing parties' claims of urgency and their subsequent inaction. In the interest of judicial efficiency and the welfare of my children, I request that the court prioritize the review and disposition of these motions with a critical eye towards their merit and necessity. The path to justice is being obstructed by a barricade of unfounded emergency motions, and it is within the power of this honorable court to clear the way. I stand ready to engage constructively with the court's processes, to respect its time, and to uphold its directives. However, it is imperative that the court addresses this pattern of behavior that serves to derail our collective efforts to reach a fair and final resolution. In closing, It is time to move forward, to act decisively on motions that have lingered without just cause, and to bring this case out of the procedural quagmire it is mired in. For the sake of my children and the principles of justice, I seek the court's assistance in bringing these matters to a close. Thank you. That was the statement I prepared for the court this morning, and was so rudely, so oppressively not able to say. I'm at a loss of words. I feel like our country is lost, democracy is lost.
Don't say goodbye. Don't make me cry.
That's the first time I ever saw that lady. I don't know who she is. For her to come in and start talking to me that way is discouraging at best. To disparage me and admonish me before I even spoke. To allow the other counselor to speak before me when I scheduled the hearing. And to never allow me to even say one complete sentence without interrupting me. I'm baffled, I'm dumbfounded. I'm shocked. And now my babies are gonna have to wait months more. My vote for today was for them to just look at the injunction and vacate that so my children can have a father. I wasn't even allowed to mention it. It's as if the kids in this case don't exist. On that, I'll sign off, and I look forward to hearing what you have to say. Was that fair and impartial? Was that equal access to justice under the law? I look forward to hearing your response.
Don't say goodbye. Don't make